Judge Shima. I'm clerk of the appellate courts and the Supreme Court and the Court of Appeals. You guys are in a special treat tonight, having a session of the Supreme Court here in a night session. You also have a unique opportunity, and I encourage each one of you to participate in the reception afterwards. It's unique because this is an opportunity, if you want to talk to all 7 justices on the Kansas Supreme Court, they will be there for you, all in the same room, and they will be glad to talk to every one of you. So take care of that, or take that opportunity if that's something that you want to do. One of the most important things to remember tonight is your cell phones. These have to be completely powered off. Make sure they're completely powered off. There's no electronic transmission of the proceedings today. We are live streaming those, and at the same time we are archiving those on the Kansas Supreme Court website. So if you really want to rewatch these arguments, you can do that in a couple days. We do a pretty good job of getting those back up onto the computer on the kansascourts.com website, and you can watch those again. Again, make sure your cell phones are completely powered off. Now, it's my pleasure and honor to introduce Judge Merle Wilson, who is the Chief Judge of the 21st Judicial District. That covers Riley and Clay counties, and he's going to give you a little bit of an introduction of the cases you're going to hear tonight. Good evening.
As I indicated, my name is Merle Wilson, and I'm the Chief Judge of the 21st Judicial District. Proud graduate of Manhattan High School, class of '67. It's an honor to be here. I think Principal Hoyt was a student of my wife and taught here for 35 years, so it's always good to come back. So we're going to hear 2 cases this evening, and so I'm going to give you just a little bit of background on the cases. The first one is the state of Kansas versus Lee Williams. Mr. Williams was charged with a first-degree murder out of Kansas City, Wyandotte County. After a jury trial, he was convicted of that, along with a couple other associated crimes, and sentenced to the Department of Corrections for life without the possibility of parole for 50 years. There are really 3 main issues on this case. The first one is that Mr. Williams, who his attorneys were claiming that the state's prosecuting attorney committed error when they made reference in closing arguments to a witness being a liar. The second issue involves what we commonly know as a Batson challenge, and that's during the selection of jurors. And in this case, Mr. Williams challenged the fact that the state removed from the jury panel some African Americans, and in those situations that happens, the law requires that the state give a race-neutral reason why that person was removed. And so they're claiming error there. And then the third issue is that the court erred when they admitted overly gruesome pictures of the deceased victim. And then finally, a catch-all of, you add all those together, and it makes major error. The second case that you'll hear is out of Dickinson County, in the Abilene area, and it involves state of Kansas versus Julia Evans. Miss Evans was involved in an automobile accident on Interstate 70. It actually was a rollover accident to the extent that it required EMS to extradite her from her vehicle. At that point, they placed her on a body board and transferred her to a hospital. The deputies who were investigating the accident were trying to determine who Miss Evans was, and so they looked into her car, saw her purse, and thought that perhaps her driver's license was in the purse. They opened the purse, looked in there, and found drugs. And so the issue then becomes whether that was an illegal search by the officers, and that would require the suppression of that evidence. And then, so I mean, that's there's some other fine points along with that you'll hear about too. But that's a summary of the 2 cases that you'll hear this evening. I hope you give your attention to this, and it's nice to see so many people here. Thanks for coming.
All rise. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court now sitting.
Thank you. Please be seated. Good evening. Good evening. That's much better. Welcome to this special session of the Kansas Supreme Court. We are very pleased to be holding it in the auditorium at Manhattan High School. Since 2011, our court has made an effort to be more accessible to the nearly 3 million Kansans that we serve by seeing firsthand who we are, what we do, and how we do it. Kansans learn more about the Supreme Court and our judiciary. For example, tonight we will not be doing a public opinion survey, nor will we be asking you to tell us how you think we should decide these cases. But we will ask the attorneys questions to help us do our job, which is to interpret the law and to make decisions that the law requires, and not based on our personal beliefs or because of politics or because of special interests. We strive to maintain fair and impartial courts for all Kansans, for, as a man named Thomas Jefferson said about 200 years ago, the most sacred of the duties of a government is to do equal and impartial justice to all of its citizens. This is the Supreme Court's first visit to Manhattan in the court's 157-year history, and this is the 9th time that we have heard cases argued in the evening. And we hold court in the evening on these special occasions because we realize that most people would have to miss if we held court during the workday or the school day. So far, we have held special sessions in my hometown of Salina, Greensburg, Overland Park, Wichita, Pittsburgh, Kansas City, Kansas, Hayes, Garden City, Topeka, Hiawatha, Hutchinson, Winfield, Emporia, and Colby. To paraphrase an old Beach Boys song that Justice Beyer and Justice Johnson like to sing, round, round, get around, we get around. I would now like to introduce my colleagues on the stage before you, and I'll do so in order of seniority. To my right, this is Justice Marla Lukert. She's a native of Goodland on the far western border. On my left, this is Justice Carol Beyer, originally from Kansas City, Kansas, on the far eastern border of Kansas. To Justice Lukert's right, this is Justice Eric Rosen. He's a native of Topeka. To Justice Beyer's left, this is Justice Lee Johnson, who's a native of Caldwell on the far southern border. To the far right, this is Justice Dan Biles, originally from El Dorado. And to the far left, this is Justice Caleb Spiegel, originally from Lawrence. As you probably can guess, an activity this tremendous takes an awful lot of hard work by a lot of people. So I'd like to take a moment to thank the many people who helped make this such a successful event. I want to start by thanking USD 383 Superintendent Dr. Marvin Wade and Manhattan High School Principal Greg Hoyt. You and your staff have gone out of your way to help our staff plan this event, and we appreciate your hard work and your enthusiasm. So we extend a warm welcome to Superintendent Wade, Principal Hoyt, and all the educators, staff, and students who are in attendance. This session is being video streamed, and we appreciate the expertise of the high school staff for helping make this possible. I also want to thank all law enforcement and security personnel who have assisted in planning and providing security during our 2-day trip to Manhattan. A special thank you to the Kansas Highway Patrol and the Riley County Police Department. Also, a welcome to Chief Judge Merle Wilson and the other judges and court staff of the 21st Judicial District who are in attendance. Thank you for helping with the planning. And a thank you to our honorary bailiff, Molly Kiava. Molly has been a court reporter for Riley County District Court since 1988, and she's been the court reporter for Chief Judge Merle Wilson since 1997. Molly, we commend you on your many years of public service, and we thank you for opening our session this evening. We welcome the Riley County Bar Association members who are in attendance, and we had a lot of fun with you at our luncheon earlier today. Before we came this evening, my colleagues teamed up with a number of your local judges, and they visited schools in the area. And I'd like to mention those schools and the justices and justices who did participate in that activity. At Manhattan High School, here, Justice Biles and District Judge Grant Bannister. Junction City High School, Justice Stiegel and District Judge John Bosch. Wamego High School, Justice Beyer and District Judge Jeff Elder from the 2nd Judicial District. Rock Creek High School, Justice Johnson and District Magistrate Judge James Keppel. Chapman High School, Justice Rosen and District Magistrate Judge William Malcolm. Kansas State University, Justice Lukert and Chief Judge Kim Cudney from the 12th Judicial District. By our estimate, about 1,100 students attended those sessions. We want to thank you all for coming this evening and for helping us make history. With your help, this should be a great session. And we invite you to a reception in the Commons area after the oral arguments are done. We welcome the opportunity to shake your hand and to visit with you and to try to answer whatever questions you might have. I'm now going to turn to Mr. Doug Shema, the clerk of the Supreme Court, and ask him to do the honor of calling this evening's docket. Mr. Shema.
Thank you, Your Honor. May it please the court. The docket for Monday, September 24th, 2018 consists of 2 cases. First case, appeal number 116690, State of Kansas versus Lee Edward Williams, Wyandotte County, briefs both sides.
Peter Meharry for Lee Williams, present and ready for argument.
State of Kansas, appellee, appearing by and through Lois Moline, Assistant District Attorney, ready and wet. Ready, Your Honor.
Second case, appeal number 119458, State of Kansas versus Julia Colleen Evans, Dickinson County, briefs both sides.
Darrell Hawkins, Assistant Dickinson County Attorney, ready for argument.
Whitney Caulfield, North Central Regional Public Defender's Office for Julia Colleen Evans, present and ready for argument.
Counsel, if you could stay at the lectern and ask you to be joined by your opposing counsel, Mr. Hawkins, if you'd both come to the lectern. As you probably saw by the program that we had printed a week or so ago, the case that these 2 lawyers are appearing on tonight is not listed in the program. I want to let you know that last Friday morning, we got word that that case, which was Davis versus Judd, basically the controversy had been resolved, and we spent a lot of time Friday trying to find a case that would be substituted for this evening. So if you can imagine arguing a case in front of hundreds of people with about 2 days prepared for oral arguments, not every lawyer in Kansas wants to do that. These 2 lawyers said, yes, we will do that. And I just wanted to publicly thank them on behalf of the court for doing that. Thank you very much.
You're welcome.
Your Honor, that concludes the docket for tonight.
Thank you, Mr. Shema. I wanted to briefly announce that we're going to proceed with hearing both cases without a break in between the oral arguments. If at any time you feel you need to leave the auditorium, please do so, but so you do not distract counsel or the justice system asking questions. We would ask that you do so as quietly as you can. You're always welcome to come back. I will now officially call the first case on this evening's docket. It is case number 116690, State of Kansas v. Lee Edward Williams.
May it please the court, Peter Meharry for Lee Williams. If I could have 3 minutes of my time for rebuttal, Your Honor.
3 minutes is granted.
Thank you. This case comes before the court after Mr. Williams' conviction for first-degree premeditated murder. He was also convicted of a separate charge of criminal possession of a firearm. His sentence was life imprisonment without the possibility of parole for 25 years, followed by a sentence of 20 months for the criminal possession charge. The facts of this case and the charges of this case arose out of an incident on September 4th, 2013. Ultimately, the victim in this case was shot and died from those wounds. How that came about was the subject of disputed testimony. The state's allegations and witnesses testified that my client, Mr. Williams, and the victim had an on and off relationship over the years. They also had a child together. And in the early morning hours of September 4th, they got into an argument. The testimony from two witnesses, one being the grandmother of the victim and the other being an aunt of the victim. They both testified they heard a commotion in the house. They came down to see my client trying to drag the victim out of the house. They both intervened, and at that point, my client proceeded to shoot the victim. My client testified that he was at the house, and there was an altercation between them. However, his testimony was that they got into an argument. He proceeded to grab their child and was going to leave the residence when the victim pulled a gun on him. He set down his child, and then the two struggled over the gun. During that struggle, the firearm went off, resulting in her death. From that, we have raised 3 issues in our brief. What I'd like to do is go through the first 2, and then time permitting, maybe touch on the third. The first issue deals with our allegation that the prosecution improperly, in closing arguments, called my client, Mr. Williams, a liar. As this court has said over the years, it is improper for the state to call the defendant a liar in closing arguments. This goes back to Pabst, where this court has said that that is a comment on the credibility of the witness, and that is improper for the state. Credibility is solely left to the jury, and neither side can comment on the credibility of witnesses. In this case, particularly, the comments we have problems with are when the prosecutor argued to the jury that my client made up his story as he was testifying, and further that his story was false and a fabrication. We believe that when you look at this court's prior cases such as Elnicki and Brown, which we've cited in our brief, this court has said such comments are improper as they amount, while they don't use the term liar, they're one and the same. And again, that is a comment on the credibility of the witness such that it is improper for the state to do.
But haven't we also asked, or in our review, looked at the context of those statements? And here, before those statements were made, the prosecutor told the jury it would be their duty to decide the credibility of the witnesses, told them that you heard 2 divergent views, and then said, I'm going to tell you the reason the evidence stacks up so that you should not believe the defendant's version. Isn't that different than calling the person a liar?
I think if the state would have done that, I would argue that that's arguing the evidence, but I don't think that's what the state did. The state did go through the evidence and say, this is what the evidence shows, but then the state went the next step and says, I'm going to suggest to you that the defendant made a lot of his story up. That's not a comment on the evidence, that's a comment on my client's credibility. When the state says, I'm going through this evidence, and then says, which I suggest to you shows that this version is false, his version is a fabrication. It's that next step that I think we run into the problem. We don't have a problem with the state saying, this is what the doctor testified to, or this is what the witnesses testified to. That's not consistent with what the defendant has testified to. It's that next step where the state then goes and says, I'm suggesting to you, the jury, that's a fabrication. And I think when the state makes that type of comment, it is a comment on the credibility of my client. It is putting the backing of the state behind that and arguing to the jury, look, we know, we're the state, he's lying to you. And this court has said from Pabst through multiple cases, the state can't do that. And that's where we have a problem with the comments from the state in this case. It's just that extra step where the state goes on to say, look, it's a fabrication.
So
His
it's the
story
use-
is made up.
Counsel, it's the use of the word fabrication or made it up, made a lot of the story up. That's the part you're objecting to, or is it the suggest, I suggest part, or is it both?
I think it's the whole sentence. I suggest to you that this is a fabrication. I suggest to you he's making his story up.
And in your view, the law is that even if both of those statements are swimming in a recitation of the evidence and the ways in which the evidence contradicts his story, that once those words are uttered, we have error.
I believe that that is improper. That is commenting on the credibility of the witness in this case, and that is what this court has said the state can't do.
But we've said the court that the prosecutor can point out where there's conflicting stories or conflicting versions, that the prosecutor can point out why the jury should believe one over the other, and that's what he was doing here. And he says that's what we're getting at. You're going to have to go in there and say, am I believing Ernestine and Laura, or am I believing what the defendant had to say? That's the sentence that preface what I'm going to suggest. And then he says, I'm going to suggest that he made the story up as he testified on the stand, asking that, hey, you saw this guy, and here's the two conflicting stories, and here's all the evidence, and here's why you should believe my version. And we've said that's okay, haven't we?
Yeah, and I don't have a problem with the state getting up there and arguing all the evidence. I point to my two witnesses, the aunt and the grandmother, the medical evidence. I don't have a problem with the state saying that shows that this was a premeditated killing. It's when the state then says, I'm going to suggest to you he's making this up.
Didn't the state actually say, I'm going to suggest to you that this shows, and isn't the this shows an important part of the sentence that you're sort of eliding?
What I'm looking at, Your Honor, is volume 17, page 586, and it
Is
says,
that the defendant made up a lot of the story?
I'm going to suggest to you that the defendant made up a lot of his story
And
as he testified on the stand.
There's no, that this shows, that doesn't show up in that sentence, but the later portion of the transcript that you complain about where the prosecutor uses the words, his version is false, his version is fabricated, is preceded by, I suggest to you that this shows, he's talking about the physical evidence, that his version is false. Does that make a difference in your view?
I don't think so, because I think you still have the prosecutor saying, I suggest to you this is fabricated.
Can the prosecutor say, I suggest to you that the evidence shows?
I think the prosecutor can say, I suggest to you the evidence shows this was a premeditated murder. But I don't think he can go beyond that and start commenting on the credibility of my client's testimony. I think that's where, from my reading of the case law, is where the line has been drawn, is that you can't make that comment because that is left for the jury.
And speaking of case law, what is the strongest case that you rely upon for your position?
I would point the court back to both Ilnicki and Brown. I believe that both of those cases use similar language. And in both of those cases, this court said that that was improper, where the state was commenting on the credibility of the witness, and that goes beyond what they can do in closing arguments.
Let me move you over to the other issues while you still have some time. On the jury selection issue, you had 3 jurors who were African American that were struck by the state through peremptory challenges. One of those is juror number 29. As I read I want to just confirm this. As I read your brief, you don't have a problem with that. That was a race-neutral reason when the state said they struck him because he was unemployed, right?
That is correct, Your Honor.
Okay, so we're only focusing on jurors 12 and 13.
Yes.
Okay. And then on the photographs, I had a little problem with, there are 5 photographs involved. You don't really challenge the 2 photographs on the second shot. You know the ones I'm talking about. They're just kind of, I mean, they're bullet holes in the body, but it's not.
The focus.
I mean, the other 3 are more stimulating.
That's correct, Your Honor. Yeah, the focus would be on the other ones, particularly the ones that's showing the facial wound and the one with the rod showing trajectory.
So focusing on the 3, which is a bullet wound to the face, to the left eye, I think it is. Let's assume it's error. Make the case that it would be reversible, that it's not harmless.
I think in this case, the problem we have with admitting those is it does play on the sympathy of the jury. It creates sympathy for the victim in this case, and it's particularly harmful because the jury sees that during the case state in chief before my client gets on the stand. And I think he already kind of has one strike against him once he gets on the stand. In this case, his testimony was that this was not premeditated first-degree murder. It was self-defense, or at least a lesser degree. So it's vital for him when he gets on the stand that he gets a clean slate from the jury, that they will take him and view his testimony without any prior biases against him. And I think when they put in those pictures, that does create that inherent bias, inherent favor for the victim in this case, and to push the jury to convict because of what she suffered. And that way his defense is undercut because he's not really given that fair shake when he gets up and testifies in front of the jury.
Could we back up to the race-neutral explanation given for the peremptory challenges on the jurors number 12 and 13? What is your particular issue with how that played out? One was talking about a profession that the prosecutor didn't particularly want that person with that employment on the jury. Why isn't that race neutral?
I think, it probably is race neutral. The problem I have with what the prosecutor stated for their reasons for striking these jurors is they essentially don't make any sense. I think they show a pretext more than anything. Pretext that we're going to strike these people. We can't say it's for race, so we got to come up with some reason.
What do you base the pretext on when you say it is a race-neutral reason, but it's a pretext? Why? How can we conclude that?
I think this court can look at the reasons stated for striking these jurors and say these make no logical sense. They don't make any legal sense. And that can be seen as a mask for the real reason that they were struck. I certainly understand the standards involved in Batson, and I understand, the odds are high. But I think this court can look at what the prosecutor stated as for the reason for striking these jurors and ask itself, does that make any sense? With juror 12, it was what the prosecutor didn't know if it was a male or a female. What does that matter? Why do we care? That doesn't exclude anybody from being on a jury.
It's interesting the distinction that we draw between a non-minority peremptory challenge, which can basically be for anything, but then when you have to articulate a reason, what creates the difference in exercising the peremptory?
Well, I think that what creates a difference is Batson versus Kentucky, and the finding that striking minority jurors violates the Equal Protection Clause of the Constitution. And certainly, this court, I'm sure, is well aware of the history behind striking minorities from jurors. It has been a problem over the years, and Batson versus Kentucky, they found that that was
But if
violate.
the reason is I don't like this person who's engaged in this particular profession, and that suffices for a non-minority peremptory, because you don't have to state what the reason is. Why, and it's a race-neutral reason, why doesn't that suffice then for this?
Because I think when you look at the rest of the jury panels, there were others that were similarly situated than this person, but were not struck.
Were any of those arguments made below about the people who were similar in these respects, the reasons given by the prosecution?
It wasn't articulated, Your Honor, you know, and I recognize
So that's one
that
problem for you.
there is a problem with the record made below.
Right. And then, because it is your burden on step 3 in Batson to demonstrate pretext or,
Under Batson, the burden is placed on the defendant to show that there
or
was.
if not pretext, that they're not believable in
Right.
some way. And we just can't judge credibility up here the way that a trial court can.
Arguably, I don't know if I necessarily agree with that. I understand this court has said that, and that is this court's case law.
Do you think something about that deviates from Batson?
I don't think there's any case law that I can cite to that would say it does. But I would argue to this court can look at the reasons given. This court can look at Voigt-Dyer and look at who was picked and who was not picked. And I think this court can come up with its own conclusions as to what was the basis for those picks.
In this particular case, did you end up with any minority jurors, any African-American jurors?
The makeup of the jury, I know there were minorities. There were both Hispanic, African-American, and I believe one Asian.
Who actually served?
Who actually served, yes, Your Honor.
Okay, thank you.
To continue on the vein that Justice Breyer was talking about, your burden and standards of review, once the trial judge has made his or her decision that this does not meet the Batson challenge, we review that decision under an abuse of discretion standard, correct?
That is correct, Your Honor.
And what particular type of discretion are you arguing was abused by this trial judge?
I think for one thing, and if you look at the Voigt-Dyer in this case, I don't know that the district court ever actually got to the third step. If you look at what the district court said, it basically said, after the state said, these are the reasons why I'm striking these jurors, the district court said, those are race neutral, so I'm going to deny your Batson challenge.
So in other words, of the 3 types of abuse of discretion, you're saying that the district judge applied the wrong legal standard?
Yes, Your Honor. I don't think the district court made that determination on the credibility of the stated reasons. It just basically said, and this is volume 18, if you look at what the district court says, and this is page 133, they are all race-neutral explanations, and I will deny the Batson challenge on number 12. For number 13, he said, certainly striking for age is a race-neutral explanation, so I'll deny your Batson challenge. I don't think the court ever made any credibility determination on that. You know, it just seemed to say, I got a race-neutral reason, and that's enough. And I don't think necessarily under Batson that is.
Counsel, you're well out of time. Do you need about 15 seconds to wrap up, or we'll just wait to see you on rebuttal?
Rebuttal is fine, Your Honor.
Very well, thank you.
Thank you.
If it please the court, the state of Kansas appears by and through Lois Moline, Assistant District Attorney. The facts as set forth by my colleague here were appropriate. I do think there are additional facts that might be important to look at, especially if there was any kind of analysis of harmless error here. And I think part of it goes towards the first issue which is that, that the prosecutor, during his closing arguments, made statements basically alleging that he made statements calling the defendant a liar. We would argue that, in fact, that's not what he said at all. I mean, yes, he did say fabrication. He used that word. He used other words, but in the context they were stated, the intent here of the prosecutor, if you look at the context and the whole sentences, he wasn't calling him a liar. For example, in the statement that's been complained of, where the prosecutor said, "I'm going to suggest to you that the defendant made a lot of his story up as he testified on the stand," the rest of the same sentence was, or while he was on the stand, "and I'm going to get to that in this way." In other words, the prosecutor made a statement and then told the jury, and how I get to my suggestion is, and at which point he then started laying out the actual facts and how they didn't match the defendant's statement.
Is there a difference between saying he made the story up or he's lying, and I'm going to tell you why? Is there a difference between those two?
I think if the only thing the prosecutor says is you heard the defendant and he's a liar or he's lying, as opposed to explaining why you want to suggest that this is, he fabricated it, and pointing out actual evidence that was admitted during the trial, I do think there's a difference. Yes.
Is it the characterization of the lie, of calling someone a liar versus someone who's not being truthful? Is that kind of the distinction here?
I don't think so, no. I think it's the way it's approached and how it's explained. In other words, the entire sentence or the entire paragraph instead of the phrase that uses fabrication or whatever whatever word is used. And in this case, I think that the prosecutor started out at the beginning saying, you know, you have two different versions, jury, and it's your job to decide which version, and you can look at the facts to do that, and I'm going to suggest that the defendant's version is fabricated based on fact. And then he closes that up a couple pages later, after lots of talking, so that I suggest to you that the version given by Laura and Grandma, which I'm sorry are the aunt and the grandma, and he goes on to suggest that that's the one you should believe because again, how the facts match these two different statements. If the court were to find that one or more of these statements were error, in other words, he went too far in using the word fabrication or something along that line, I would argue that the court could also find in this case that it's harmless error. He wasn't flat out calling the defendant a liar. He was definitely addressing these statements to the facts that were adduced and asking the jury to find whether or not the defendant had told the truth when he talked about this, for them to compare the facts to his statements, but also that the evidence against him was overwhelming. 2 eyewitnesses testified about what they saw. They heard lots of physical evidence, which went along with their statements, whereas the physical evidence didn't match up his statement of how this shooting actually occurred. Of course, there are other facts that go along with it too, like he took the gun with him. He claimed he lost the gun. He then immediately left for Canada within a matter of a very short time. All of this evidence goes towards his guilt, and I would argue that even if the prosecutor had overstepped his bounds, that in fact it would be harmless error.
Would that be true even if we pile on error because of the word fabricate? You know, his version is fabricated.
Right.
Now, it's hard for me to separate out his version is fabricated from the Brown case, which I also think was out of Wyandotte County, if I remember. I think that's one of mine, but where the prosecutor from your office said that the defendant had the weekend to come up with a story. The phrase was "come up with a story." I'm having a hard time making a distinction between coming up with a story and his version is fabricated. But take that one and then add on to the arguments the defendant's making about the prosecutor using his credibility.
Right.
With some of these other statements that are in the closing. The one I focus on is right up above that in the transcript where he talks about that, let's see, I suggest the defendant testified to you, and to be honest about that, that was quite confusing version of the facts. Now, that's not calling somebody a liar. That, to me, that's saying, I think that's a confusing thing. And so it seems to me we have the prosecutor moving over into the area of calling the guy a liar, and on other aspects of the case, putting his personal credibility, the credibility of the state, if you will. And if we pile that on to this, do we get any closer to reversibility?
I don't believe so. I do think that saying "I suggest" is probably not the best way to say the exact same thing in another way, because there is that indication that it's trying to use its personal opinion here. I would say, as to the confusion, that was quite a confusing version of the facts. That again, that's part of a sentence, because he says the whole sentence is that was quite a confusing version of facts that he gave, when he could say, I don't even know how the gun was fired and who fired it. The cross-examination of the defendant, when he has described this event and how the shooting happened, there was lots of questions, well, how did this happen and how did that happen? And the defendant wasn't able to answer those questions, and he claimed he didn't know how the gun was going off, and he didn't know how the shots hit the victim, and his version and the actual physical evidence didn't match up, but he couldn't explain any of that. I think that the jury would have heard this not that very long before these closing arguments, would have seen that testimony, and and maybe saying his own version of that, saying it in such a way that it indicated it was his belief, but but in fact, he points out specifically, this is what you just heard, and that is a confusing version of the facts.
Here's what I guess I'm reducing this to. What other evidence did you have besides the conflicting testimony where the jury was going to have to decide the case on credibility? I mean, it seems to me they either believe the aunt and the grandmother, or they believe him because it's about a struggle and all that. What other evidence did you have that would indicate guilt besides deciding the credibility?
Okay, well, I would say he admitted, he put himself there, he put himself with his hand on that gun. When it was firing, he took the gun with him and said he had lost it on the walk home, and then he immediately fled to Canada, and was caught as he was crossing the border. All of those are completely outside the statements made by the aunt and the grandma, which also do point to his guilt. That the physical evidence of the way that these two wounds occurred, and the part of her body that was hit, and the angles and stuff. For example, supposedly she got shot in the forehead, going downwards into her face, down into her chest, but it was from 2 to 3 feet away, so it would be pretty hard for her to have done that herself, which is one of the things the defendant tried to imply by his description of how the events happened. So the physical evidence of the 2 gunshot wounds doesn't match his version at all, and match as much as they are. The two older women basically were saying he was shooting at her lots of times, so they don't say a lot of details.
He also said she sat up too, didn't he?
Excuse me?
He also said she sat up before he left.
That is right. I would agree with you, Justice. He said in his statement that the last thing he saw before he left the house after the shooting was the victim was sitting there, and he didn't even know she'd been shot. But the evidence was, and the photographs you all have seen include the fact that she was shot in the face, which went in one place in her face and came out in another place in her face, and would have most likely had quite a bit of blood. And he claimed he saw her sitting there, and he didn't even know she'd been shot. He found that out. He found that out some other day by a third party, but he'd already fled to Canada prior to that. So all of those things also point to his guilt in this matter, I would argue.
I can't remember. I have an impression, but I can't pull it out. Did you guys establish that the entry wound into the left, over by the left eye, was the first shot? I can't remember the order of the bullets.
I don't think there was any way for the doctor to detail that. The second shot into the back definitely definitely was the kill shot, because that entered the heart. The first one wouldn't necessarily have killed her, and it's possible that it caused her body to, I mean, she might have been moving, and then, because she ended up on her front before the EMTs turned her over. She was face down, and the second shot did enter her back, so it could easily have entered after she rolled over. But the doctor wasn't really asked that very specific question.
Counsel?
Sure.
I was going to follow up on that, but if you're moving to another area, go ahead. That's fine. I was just going to address, this doubles back to what Justice Stiegel was talking about in the closing argument. The paragraph, the shot could not have been fired by Tisha,
yeah.
She's not going to be able to shoot herself coming from behind in the manner in which the doctor testified. It just can't physically happen.
Right.
So this is going to what you're talking about?
Yes,
shots?
yes. But based on the stippling, which was a very important fact, the doctor opined that the gun had to have been 2 to 3 feet away, close enough to leave a little bit of stippling, but not near close enough to be like up against her head. And if anyone were to try, such as a juror, to figure out how she managed to shoot herself from above 2 or 3 feet away into her own face, it doesn't seem to be rational. And so at least that's the argument, that this doesn't match his version of events at all. So.
Which the prosecutor said, I suggest to you that shows his version is false, his version is fabricated.
Right. And that's what he was pointing out, yes.
Counsel, I wanted to talk about Batson.
Sure, yes.
Maybe what its limits are, what protection, if any, it actually offers. And that's, you're kind of smiling because I know you're understanding where I'm going here. I think the phrase is race-neutral reason, right?
Right.
So if we could move for a moment from the race-neutral and talk about a reason. And it just seems to me that some of the reasons, we'll use that word temporarily, that the prosecution gave here just have nothing to do with jury service, period. And so does Batson mean anything more than race neutrality? Does it mean they have to be sensible or logical, as your opponent suggests, or is that just not part of it?
Well, I wouldn't disagree that logical makes sense, and I would actually agree that a couple of these reasons don't make a lot of sense. But in fact, the prosecutor in this case gave more than one reason for both Juror 12 and Juror 13. The judge basically focused on one in each and found race neutral.
13, I think, to me, they sound like the same thing, stated two different ways. Being only 19 and not having life experience sound like the same thing to me.
Oh, and also that this is one of the jurors that wasn't married. That was another thing. Now, the judge never addressed that one, but that was a third, actually, that was also said within like the same sentence or the next sentence.
Okay.
So the prosecutor had given a number of reasons for that second juror.
Okay.
I would say that being very young and not having any life experience is a rational reason why you might not want a particular juror on the stand.
That one sounds a little more reasonable to me than the prosecutor isn't quite certain what gender someone is. I can't figure
that
out.
one actually didn't make a lot of sense to me either. But it was But you know, when you're put on the spot, and I've been there, where basically the judge turns to you and you're looking at all your notes, trying to remember what all you wrote down, and possibly you just start saying all these reasons you have in front of you, and maybe at that moment that one doesn't make a lot of sense. But the other reasons, I mean, why I think a particular profession isn't a good profession.
Counselor, if you have an African American defendant.
Yes.
And you have African Americans on the veneer panel.
Right.
Why wouldn't you be prepared to back up your peremptory strikes of the same minority, knowing Batson's been there for decades? So I don't know why it should be a spur-of-the-moment thing for the prosecutor. You know this is out there.
True, and some of that stuff you get from the jury questionnaire, some of the information. So maybe you had a few moments to look at that ahead of time. In Brunswick County, we don't get our jury questionnaires. We get them for about 20 minutes right before voir dire. So it's no time to hardly read 50 jury questionnaires.
Just as Johnson just pointed out, you're exercising at the end of jury selection your
Right.
peremptory challenges.
Right.
And if you notice that this
I agree.
relationship, shouldn't you be ready to explain to the court why you're excusing this particular jury that fits into the Batson paradigm? I mean, what's so hard about that?
I think that in both
And
cases,
so I don't
they
recognize
listed
a
reasons why they.
I don't recognize, I didn't recognize the person's gender is,
I don't know why he said that.
well, that's the point.
But juror 12,
But then
this
he
is juror
added
12.
two other things too. He didn't just say that.
Yeah, that saw perhaps the juror nodding off, which no one else saw.
Well, what the judge said is, I didn't see them sleeping, but in fact, a person can nod for a second, and maybe people didn't see them
guess
sleeping. I
that's-
wouldn't argue that those are the exact same phrases.
That was my point, though, that I made to counsel for Mr. Williams, is that it's more than just exercising a peremptory challenge for a non-minority juror.
Right.
You can just kind of do that. You don't have to
Right.
give any explanation. Here you do. And I'm just struck by the explanations being so, it just didn't seem to fit with the purpose of Batson or the purpose of, or the function of a juror. It just,
Well,
it seemed to be missing.
so if you were, if a prosecutor is questioning a juror and notices their head nod a couple times, I would note that. That would absolutely be some reason I might not want that juror. And because the judge doesn't ever actually see them sleeping as opposed to nodding off, I don't know that that means that the prosecutor was lying. It means that that's something they observed. And it's a very legitimate reason why you wouldn't want somebody on the jury, I think, that they weren't paying attention. Jury rooms are always hot, and they're always crowded full of people when we're doing voir dire, and I had a juror, we realized as we took a break, there was a juror sleeping on and nobody had even noticed it, and we don't know how long he'd been sleeping, so he ended up not being on the
Counsel?
jury.
Assume for a minute that we agree with you.
Okay.
That whatever reasons were given are race neutral and
Right.
they're actual reasons.
Mhm.
Does that end the inquiry?
No, because the next step that's required is the third step,
Right.
because the
and
defendant has the
The
burden then.
defendant is suggesting
Right.
that he never had the opportunity to prove up his allegation of of a race-based strike.
And when he said that here just a few moments ago, I looked at that because that struck me as that I didn't remember that at all. The state, and I'm here in volume 18, and this all starts on page 131, but then if you go to page 132, the state has, in the middle of that page, the state has listed out his 3 reasons, including the one about the gender. He lists out his 3 reasons. The judge then turned to the defense attorney, whose name is actually Klein Boone, and it says Klein, at which point Mr. Boone then talks about things, and he's had an opportunity to say what he needs to say. So the judge did ask for a response, and the same on juror 13, which that comes up at the bottom of 133. Mr. Gorman, the prosecutor, had again stated his reasons, at which point Mr. Boone then talked for the next couple paragraphs. So
but
it's not that the judge...
Can't the defendant or defense counsel challenge the race neutrality of the reasons?
Sure.
And that's still the second step, though. That's still the second step. The third step is all the race neutrality does is shifts the burden from you back to the defense. That's all it does. And then the defense has the obligation to show that you're engaging in a pattern of discrimination based on race.
Right.
Okay? So while you're arguing whether you have met the burden or the level to shift the burden back to the defense, you're not simultaneously discussing the third step, are you?
If I may, Step 2, according to State v. Kettler, 299 Ken 448, I cited in my brief, it's one of the many cases that cites the 3 steps and goes into detail on them. And it talks about the second case, the second step. It says, and I quote, the reason given must be facially valid, but it does not need to be persuasive or plausible. I find that an interesting case under this discussion we're having. The reason offered will be deemed race neutral unless a discriminatory intent is inherent in the explanation. The opponent of the strike continues to bear the burden of persuasion, at which point it goes to the third step, and where the court has to make a decision. But there's lots of case law saying that the defense has a burden then to whether or not it's race neutral, whether or not it...
No, the third step, the decision is whether the state has engaged in a pattern of discriminatory practice by striking the minorities. And you're already past the race neutral finding. And what we're getting at is, did the judge here ever finish off the analysis by saying they were not only race neutral reasons, but I'm convinced that the prosecutor was not engaging in discriminatory strikes. And
I don't think the judge said that phrase.
Excuse me, Counselor. That holding doesn't appear in the record, does it?
I would agree with you that the judge didn't make that specific comment, no. I would also say that I read a lot of case law when I was writing this, and I don't remember ever reading where they quote a judge saying something along that line. And I don't remember ever having a judge in front of me who's actually said those words, but I'm just letting you know.
Counsel, you're well out of time. Would you like 30 seconds to wrap up?
Just 30 seconds, Your Honors. I would just argue that in issue 1, the prosecution did not err in its statements. I do not believe it went over the line, but if you were to find that it was wrong, that I would argue that harmless error would save that particular issue. I do not believe that there was any violation by the prosecution in their strikes against African Americans. In this particular case, 3 African Americans, an Asian person, and 3 Hispanic people were all still left on the jury. I believe there were only 4 white people left at the time. I'm sorry, white jurors left at the time that the final jury, when this Batson issue came up. I don't think there was a pattern at all of the prosecution violating the Batson rules. And as for the photographs, I would just argue that the court analyzed this, and I do not. And these photographs about the angles and the stippling were very important to the state's case because, and it turned out because of the defendant's statements, they became highly important. And the fact that they might have been somewhat gruesome in no way means that they should have been kept out. That they were very important in the state's case. There.
Thank you, Counsel.
Thank you.
You're reserved 3 minutes for rebuttal.
May it please the
Can you
court.
address counsel's last point about on the Batson challenges? That you're arguing there was a pretext here to excuse minority jurors when the majority of the jury appears to be made up minorities. How does that factor into your argument that there was pretextual peremptory challenges here?
Your Honor, I don't think it changes my argument. I think that what the courts have said is that striking any juror based upon race is unconstitutional. The fact that you might have some minority jurors left on the jury panel doesn't change that it's improper and unconstitutional for the state to strike other minority jurors from that jury panel.
Can we use that fact to substitute for the judge's perhaps lack of clarity on the third step and draw a conclusion on our own that there was not a pattern because there were many minorities left?
I don't think you can. I think the fact that there were minority jurors on the panel doesn't necessarily, I guess, gloss over the fact that they used pretextual reasons to strike other minority jurors, and I don't think that fact can be...
We don't know that they were pretextual. That's what we're struggling with. And isn't the fact that there were other minorities still on the jury at least some evidence that the reasons weren't pretextual? I think that's the tenor of the question.
And I would argue no, because I think you can find that these strikes were pretextual based upon the reasons given by the state.
You look at it in the micro, we don't get to look at it in the macro.
No, and I don't think this court has ever said, you know, we work on a quota system or anything like that. You look at the individual strikes and see if those have any basis, if there's a race-neutral reason given, if those are pretextual or not.
Can Batson ever be harmless? Can a Batson error ever be harmless, under your view?
I don't believe it can, Your Honor. 'Cause I think,
I'm sorry, I didn't mean to cut you
I'm
off.
done.
I cut off your answer, I thought.
I was just going to say, once you improperly strike one juror based on race, I think you undercut and violate the Constitution such that the panel cannot be saved.
And just so I'm clear, to extend that out, if you struck panel members because of their race, African American, and you wound up with 12 African Americans on the jury, what's your position on that? Is that a problem?
I still think it's a problem, and I think when you look at Batson, it's looking at why you strike jury members. It's not looking at what's left. It's looking at who you struck and why did you strike those members. And if you are striking them based upon race, what this court, what the U.S. Supreme Court has said is that is unconstitutional and cannot be allowed. So I don't think you look at the ultimate jury. I think you look at the strikes that were taken and questioned at trial. I don't have anything further unless there are other questions from the court. I would just ask that this court reverse and remand this matter for a new trial for the reasons stated in our brief.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this evening. Court will take this matter under advisement. I now call the second case on this evening's docket, case number 119458, State of Kansas v. Julia Evans.
May it please the court, the State of Kansas appellant by and through Darrell Hawkins, Assistant Dickinson County Attorney. May I reserve 3 minutes for rebuttal, please?
3 minutes is granted.
In early July of 2017, after dark, on I-70 in Dickinson County, Julia Evans was involved in a one-car rollover accident. At the time that officers responded, they could not extricate her from the vehicle and were waiting for EMS. She was sitting in the passenger seat, feet in the driver's seat, her head between the dash and the windshield, obviously in pain. The first officer tried to talk with her, calm her, ask her name. She replied, Julie. Upon arrival of the second officer, the first officer was called away for another matter. The second officer, observing her and hearing her indications that she's hurting, again tried to talk with her, ask her name. She replied, Julie Evans. At that point, the officers had attempted to open the door to help her get out. Could not do so. EMS arrived, took over, extricated Miss Evans from the vehicle, put her on a flatboard, took her to the ambulance. The officer who was at the scene at that time asked EMS, ask her where her driver's license is because I need that. They told him, we'll do so and we'll get back with you, which obviously they never did. Ambulance leaves. The officer notes that the tow truck is there, is ready to take the vehicle, looks in the vehicle, there's a purse. As part of a community caretaking function, as part of his response to an injury accident, to safeguard the property of this individual, he takes the purse out of the vehicle. Subsequently, in looking for the driver's license, he notes that there's a little baggie with contraband, which he recognizes and believes to be methamphetamine.
That's in a wallet. Was the wallet inside the purse?
Yes.
Or beside the purse?
It was inside the
Okay,
purse.
so the purse had to be opened in order
Purse
to
had
get
to be
the
opened.
wallet, and then the wallet had to be opened in order to get to what he saw.
Correct.
Okay.
There's another fact, question I had as I was reading this, and I was from the Appellee's brief and then going to the record that was taken at the motion to suppress. At some point, prior to EMS being called or while EMS is being called, she explains to the officer that she has called her boyfriend or ex-boyfriend and wanted him to come to the scene. And I'm curious as to why that was never, do you know why that wasn't ever developed in any of the court's findings? Because the officer said that's what happened. And
I do not know. I can't answer that as to why it was
You
not
don't
further
dispute that
developed.
that took place? That's the testimony of one of your officers.
That was the information that supposedly Ms.
So,
Evans gave.
she was able to
I don't
make a
recall
phone
that there was
call.
anyone there.
Excuse me.
I'm sorry.
I'm not able to understand both of you talking at the same time.
My
Could-
apology.
If you could let Justice Rosen ask his question, then we'll let you provide your
Certainly.
answer. Thank you.
Well, my question is that she obviously made a phone call when she was found in the condition she was found in. That's what we can surmise from that. Because the boyfriend did show up at some point, asking for her personal possessions, as I understand it.
It's my understanding he showed up well after the fact, after the discovery of the
And
methamphetamine.
was there ever, and again, neither the district court, it didn't seem like it was argued at the suppression hearing, but was there a phone that ever showed up or any, I didn't see any of that.
I do not recall.
Okay, thank you.
Okay.
Once the officer took the purse and the billfold under community caretaking, can you identify specifically which warrant exceptions you are relying on for their ability to open the purse and to open the wallet?
This is part of the problem that we have here, because as the district court basically gave the law enforcement a double-edged sword, cutting them both ways. The district court said none of the exceptions to warrantless search apply. The state's perspective was that this was part of a caretaking situation. Katie versus Dombrowski from 1993, the U.S. Supreme Court, where they noted that very often law enforcement has less than criminal intent contact with citizens.
You're saying it wasn't a search at all?
I'm viewing it not as a search.
How does the record support that when the officer testifies he wants to know whether or not the driver is suspended, whether or not he wants to know if the driver is required to have an interlock device? And those seem like rationales that go to a criminal investigation, which makes this a search.
Obviously, those issues would go to it.
Well, how do
But as
you-
I recall, I'm sorry.
How do you account then for that testimony in the record?
As I recall, his testimony was not that that was what he intended to do, but that once he received a driver's license, he ran a background check on those things as a matter of policy.
Are you suggesting that the driver did not have an expectation of privacy in her purse or billfold?
No. I note, and the district court made a reference to State v. Huber, regarding the expectation of privacy in personal belongings, wallet, purse, jacket, so forth, of that nature. I would note that the individual, however, as Justice Rosen indicated, was able to make a phone call, and while in pain, never asked for her purse, never expressed a particular or a definite expectation of privacy in that purse.
Does the record tell us how much time we're talking about? How much time was she still at the scene? Did the boyfriend get there while she was still at the scene, or
No, he came,
Okay.
I believe, to law enforcement headquarters later,
never came to the scene at all?
not to my knowledge.
Okay,
no.
thank you.
Could you specify for us the answer you gave in general terms about this was part of the caretaking function? What in particular was the officer attempting to do when he took the purse, opened it, pulled the wallet out and opened it? What is he trying to do?
First, the caretaking part, he seized, and I use that term seized because he was taking it into his possession, an individual's personal property for safekeeping and to ensure that it's not lost or stolen. As a part of the looking for the driver's license, it's the state's position he was fulfilling an administrative obligation to complete an accident report.
Well, and that, I think, may be the crux of this. Were there other ways for the officer to have obtained the information about who the driver was? For example, I think there's a suggestion in some case law that you can call the dispatcher, say, run this plate, who owns this car, who's it registered to? And that way you're not getting yourself into opening a purse, opening a wallet. Was there?
That would give you certain information. Regrettably, in this day and time, the name that someone gives you, even some of the identification that is provided to you, is not legitimate. That's why he was seeking a photo ID, which in this case was the driver's license, which would allow that officer who had seen the person to match the physical description and appearance to the name on the license.
And why was that important for him to do that? Could that not have been done by the attending medical people? And again, could that not have been obtained by contacting dispatch and saying, here's a license plate number, what do you have?
Presuming that the individual who's driving the vehicle is the owner of the vehicle, but that's not in evidence in that regard, and it doesn't ensure that the officer has the definite information that he is required to provide.
The statute, I think you rely on for that position is KSA 81611, is that
Correct.
correct? But it reads, every accident report shall contain all of the information required therein, unless not available. How do you read out those unless not available to say that it has to be done?
In that reading, if one is to say that unless not available is controlling, no one's going to provide the information.
No, I think, isn't it referencing a situation just like this one where you have an injured person? And so you
Excepting
may
that
have to
here,
go-
I'm sorry?
That's all right.
Excepting that here, that information was possibly available. And there isn't a provision in the statute that says you couldn't or shouldn't look for anything to provide that background information.
Well, we're talking about the Fourth Amendment.
Correct.
And the Fourth Amendment has been interpreted such that a search without a warrant is per se unreasonable and violates the Fourth Amendment, right?
Correct.
This was a search of the purse without a warrant, was it not?
Agreed.
It's per se unreasonable. Then the state has the burden to show one of the specifically described exceptions to the warrant requirement.
And that would,
And that, I'm going back to my colleague's question. Those are consent, search incident to lawful arrest, stop and frisk, probable cause with exigent circumstances, emergency doctrine, inventory searches, plain view, and administrative searches of closely regulated businesses. Where does the need to get information to administratively fill out an accident report fit within those judicially delineated exceptions to the warrant requirement?
It does not, but that is the state's position, that this was an aspect of a community caretaking situation,
Well,
that
so-
under this limited set of facts was not an investigation centered as to an issue of crime.
Again, you're saying it's not subject to the warrant requirement.
That would be the state's position. And again, we note, and I read the case law where it was talked about that the caretaking function should never be considered as an open door towards limiting the rights under the Fourth Amendment or expanding the opportunities to get at it. But in this set of facts, the state believes that it's appropriate, that it was a legal action by law enforcement, and the suppression should not have been granted.
So your view is that the behavior in taking the purse out of the car, opening the purse, and then taking the wallet out of the purse and opening the wallet put the officer he was in a legal position, the discovery of the drugs was inadvertent, so at that point, we've got plain view. That would be your analysis?
Correct.
And that's all because the officer has a duty to get the driver's license.
Yes.
Well, what if the accident happens in front of somebody's house? Can the officer go into their house to find identification? Well, what's the difference between that scenario and going into their purse or their wallet?
In this situation, one, I'm going to presume the officer is not going to be there to safeguard the house or the contents, since it can be locked. Here, the vehicle was accessible, had been severely damaged in the rollover. He saw the purse, took it for safekeeping purposes.
And began an investigation.
He looked for the driver's license, yes. I see
So
what-
let's make this the last question, Justice Rosen. Go ahead. Go ahead.
No, the finding of the district court was that the manner in which he even searched for the license was unreasonable, in that he didn't go to where a person would normally keep a license. He went to a small zipper on the side and looked there initially, and that's where the drugs were found, and he even found that was not a reasonable means by which you would find a license. That normally and that's what the district court found. Is that finding not correct?
That finding presumes things that weren't in evidence and presumes that the district court judge has knowledge of where and how women keep items in their purse, because I've talked with others, and there's a great variety of where documents are kept in a woman's purse, whether in a wallet or side pockets or otherwise. That presumes certain things which I don't think were reasonable.
Thank you, counsel. We'll see you on rebuttal.
May it please the court, Whitney Talbot Caulfield of the North Central Regional Public Defender's Office, appearing on behalf of Julia Colleen Evans. An officer's desire to complete paperwork does not supersede the protections provided by the Fourth Amendment of the U.S. Constitution and Section 15 of the Kansas Constitution. This protection provided by the Fourth Amendment exists at all times and does not exist only when the state attempts to investigate criminal activity. Judge Sexton made factual findings supported by substantial competent evidence that an officer began his search by opening the exterior zipper pocket of a woman's wallet in order to search for a driver's license. He also made the finding that This is not where a driver's license would typically be kept. I just want to reassert that this is not the middle of the wallet where there is a plastic pocket specifically for the driver's license next to the credit cards. This is the exterior pocket where, at least in my case, I keep my coins there. My driver's license wouldn't fit in that pocket. And Judge Sexton specifically...
Does that make a difference, Counselor? That you can go into a purse, take a wallet, and you can look at in part of it, but not in the rest of it? I don't understand the concept of partial search.
The legal significance.
Yeah, the legal significance. I understand the practical. That shows more, you could draw the inference that he was fishing for fruits of a crime when he was going where he wouldn't find the license. But we're talking about the exception to the warrant requirement, and does it really make a difference if he had opened it up and seen the license in the little glassine case where it's normally kept? Would you be saying the search was okay?
No, I would not, Your Honor. The state has argued that this search was purely for the completion of paperwork. The officer needed the driver's license information, and I feel it important to assert that if he was looking for a driver's license, it would have been far more reasonable, if not still violates the Fourth Amendment, it would have been far more reasonable that he search where a driver's license was most likely to be.
There are really 3 levels, right, here of potential Fourth Amendment violation, because you have the removal of the purse from the car, first of all.
That's correct.
And then the opening of the purse and removal of the wallet. Maybe we've got 4 levels if you count taking out the wallet and then looking inside the wallet, right?
Yes, Your Honor.
And this thing went wrong from the very beginning, in your view? Or where did the officer violate the Fourth Amendment?
I believe the officer violated the Fourth Amendment when he opened the purse. And it's actually my understanding of the fact that the wallet and the purse were seated next to each other on the seat.
That's what I thought too, and that's why I asked my initial question of your colleague. So you actually think that the testimony supports something slightly different, which is that the wallet was already outside the handbag.
That's correct, Your Honor.
Okay.
And I believe that Ms. Evans' constitutional rights were violated when the officer unzipped the wallet in any manner, whether that be the exterior pocket or the middle, in order to look for this driver's license. I can see Justice Johnson getting ready to ask me a question.
Well, finish your... Sorry, I telegraphed.
I believe that it is typical behavior for the officer to perhaps accompany the injured driver to the hospital to bring her items, and this officer had multiple options to both complete his caretaking function of safekeeping this purse while Ms. Evans' ex-boyfriend arrived on the scene or at the police station without having to also have the requirement of going into the wallet for this driver's license.
Doesn't the record reflect that the officer testified he did not go to the hospital because the driver was taken to Salina, and so it was in a different county, and that because of manpower issues, they didn't have enough people on call for him to leave the county?
That's correct, Your Honor. And if we were solely talking about whether this search was reasonable simply because they found a controlled substance, that would be another point of contention. But the officer argues that, or testified that they searched this wallet purely to find this driver's license in order to complete this paperwork required by KSA 8:1611 and 1612.
You're just saying they could have taken custody
Yes.
of these items and hung on to them for either for her or for someone she designated to get them at some point, but did not have to open them.
That's correct.
That leads me to my question now, that it may be another level. Your opposing counsel keeps talking about community caretaking. I don't know that I recall any case where they've said community caretaking lets you inventory a vehicle. Usually you have to impound that. And we've said that the inventory exception requires that the particular agency have procedures and guidelines.
That's correct.
And those procedures and guidelines would then tell the officer what he or she can do with the valuables that are extracted from the vehicle. So you have the first level, in my view, that grabbing the valuables, the state hasn't shown that fit within the inventory, and the Supreme Court case they cite for their authority talks about protecting the person's valuables, protecting the officer against claims of theft, and one other reason. But anyway, that highlights why it fits within our requirement of the inventory search that there be guidelines. And there was no attempt here to set forth what the Dickinson County Sheriff's Office has for policies or procedures for inventories, is there?
No, Your Honor, there was no evidence on the record that the state was actually going to impound the vehicle, and the state's brief actually conceded that issue. There was no evidence that an inventory was set to be performed, and thus the rationale that this was to protect law enforcement and protect the owner's property must fail, because there's no evidence that the law enforcement office or agency intended to hold on to this property for any given length of time. And in fact, the facts indicate that this Miss Evans appeared at the police station wanting her things back a mere 7 hours later. So that brings me back to my my second issue under 8:1611 and 1612. The officer had just a multitude of abilities to not only complete this paperwork without searching Miss Evans' wallet, he had the ability to do so in a timely manner. So, KSA 8:1611 allows the officer 10 days to fill out this paperwork and get it to the state office. They, KSA 8:1612B also makes an exception that when this information is not available, it does not have to be provided. But the information required under these statutes is very simple. It's the name of the driver and the vehicle that was involved in the accident. The officer had both of those facts while he was on scene. If he needed additional information, he very well could have contacted Miss Evans. He could have contacted the hospital. He could have contacted the EMS personnel or Miss Evans' boyfriend, who later arrived on scene.
Counsel, your argument sounds like it's being lifted from People v. Wright, the Colorado Supreme Court. Are you familiar with that case?
I am not. I apologize, Your Honor. I can make myself familiar and brief the court at a later date if you would like me to do so.
Well, let me just repeat some of the things from that case. It was something similar where the person was in a traffic accident, was taken to the hospital, and the officer decided to look for information. The officer took her purse to the hospital, and where she was being treated, and upon being informed that she was then in the x-ray room, he opened the purse to seek her driver's license and other information needed to complete his accident report. He found drug paraphernalia. The Supreme Court of Colorado said the officer could have asked that the purse be taken to the defendant so that she could retrieve the license, could have asked to speak to the defendant in the x-ray room, or could have asked the hospital admissions office for a defendant's name and address. And that court said, trying to get this information in the way you did it, to simply fill out this accident report, that's not going to work. And I thought, based on your arguments just now, that you were familiar with that case, and that's where you were getting some of your some of your points.
No, Your Honor, it was a lucky coincidence that my argument aligned with that case.
You'll take it?
I will take
Thank
it,
you.
Your Honor.
Could we back up here for a second? And we first got this case last Friday, it just appeared to me, in confronting the situation that an officer's out there and EMS shows up, why isn't obtaining accurate, identifying information at the outset critical to just the medical intervention that takes place? And I understand the emergency doctrine hasn't been raised. I'm not certain why. Maybe because she was able to communicate and call her boyfriend, et cetera. But why isn't just initially, if she wasn't able to get it, ask her, I mean, you have weight, you have age, you have sometimes medical condition. Important information are contained on licenses and other accompanying things with identification. Why isn't that appropriate?
Well, Your Honor, the emergency doctrine applies when a person is in critical need of care, whether that is a domestic situation.
How close is she right here? I mean, she's pretty mangled. She's in an awkward position. They have to extricate her from the car. So
That's correct, Your Honor. But it's my understanding that she was at least coherent and could make that phone call to her ex-boyfriend. I've been in this accident, please come assist me. She also, I believe, advised the officer she didn't want medical attention. She simply wanted to go home and was taken to the hospital anyway. She was able to communicate with both officers throughout the entire time she was at the scene, and I believe that would have been extended to while she was in the emergency vehicle being taken to the hospital. She could have communicated whatever medical issues she had. Your Honor, I would also like to point your attention to the fact that the state has argued that there is no probable cause that exists for the court to issue a warrant, and that there were no exceptions that applied. This is an important fact because, at least as I understand the law, that is where the analysis should end. The Fourth Amendment requires that there either be probable cause to issue a warrant or that there be an exception to the warrant requirement. Neither of those exist in this situation, and yet an officer still opened a zipper to look for a driver's license in a place he never would have been able to find it. So the question I have for you is a simple one. Should the state be allowed to argue that the efficiency with which an officer completes their paperwork be able to take precedence over the protections provided by the Fourth Amendment and Section 15 of the Kansas Constitution? The answer must be no. The state is arguing that this Fourth Amendment doesn't apply when there's no criminal investigation, but that's a misinterpretation of the Fourth Amendment. As Justice Siegel asked, what if it was in front of a house? Does this give the officers the right to kick in a door and search every conceivable location for a driver's license? I would think not. Ms. Evans and every other person within the state of Kansas should be secure in their person and effects. These officers should not be rewarded for their actions to promptly complete paperwork of an accident report. And so I'd ask this court to please affirm the district court's ruling that this evidence was impermissibly seized. Thank you.
Thank you, counsel. You reserved 3 minutes for rebuttal, and I wanted to ask a question, counsel, once you got to the lectern. My question is someplace between the facts of our case and the example Justice Stiegel gave. And so my question to you is, let's assume the officer opened the wallet and did not find a driver's license. In your view, was he authorized to start looking in other parts of the vehicle, like the glove compartment, the console, up above the sun visor, something he may have found in the back seat, that it was an eyeglass bag or something like that?
I know that there are federal cases, and I apologize for not being able to cite. I know that we referenced the South Dakota versus Opperman case in the brief. Again, I note the Cady versus Dombrowski case from 1973, which I believe involved the trunk being searched of a rental vehicle because of the concern that there might be a weapon there, just as part of the community caretaking function. And this court has previously referenced that that was a persuasive argument given that limited set of facts. We still come back to the difficulty, and I think part of the frustration the state had was the district court's perspective that you can't take the purse out of the vehicle, even under community safekeeping function, which frankly makes no sense. Not in this world. The officer is obligated.
But that's not really what we have here. We don't have, I took the purse out to safekeep it for Miss Evans.
That
We
was-
have the- Well, that's fine. If he had taken the purse and taken it into police custody, that would be a different case. But that isn't our case. We have him opening up a zippered pocket in a wallet, saying he's looking for a driver's license because one of the reasons is he wanted to see if the license was suspended, which is a criminal investigation. So even if you could get over that first hurdle of community caretaking to protect the valuables of the person that wrecked the car, you still have to have, get the second step of the officer's mission of getting the license for the accident report. I don't see how you bootstrap that administrative necessity into the community caretaking.
If I may, the first officer on the scene, Deputy Longbine, was the individual who testified about checking for suspended license, so forth. The second officer, the APD officer, testified that it was his practice, if he saw what would be personal items or items that individuals might be concerned about if they lost, that he took those into possession just as a part of safekeeping. He never testified that he was looking for a license so he could run a check to see if they were suspended or revoked or anything else. And that's the point that I come back to.
But then what did he do when he took it into safekeeping?
He looked for the driver's license to fulfill the...
Well, that's the step, that's the disconnect. That's the disconnect.
Yes.
Community caretaking may get you possession of the wallet. It doesn't get you inside the zippered pocket. You have to get an exception to a warrant requirement.
But therein lies part of the problem, is that the district court argued or stated that a warrant should have been sought when law enforcement would have had no basis for a warrant because they weren't conducting a criminal investigation. And that is part of the difficulty here. It's the...
So they just would have had to wait until they could get the information another way, which the statute certainly provided was permissible. You agree that the statute did provide that that
Yes.
was permissible?
Yes.
Yeah, that's the rub. There was a
How-
big rush.
How many things in life, the woulda, coulda, shoulda,
Right.
resolved most of those? I see that I'm out of time. Thank you.
Thank you, counsel. We thank both of you for your arguments this evening. Court will take this matter under advisement. That concludes our special evening session at Manhattan High School. Thank you all. Court is now adjourned.